We want to welcome everyone to the Fourth Circuit today. We have three interesting cases and an array of good lawyers. And so we'll start with the United States versus Jamerson. Mr. Foster, good to have you with us, sir.
Thank you, sir.
You can make your argument. And you're a court appointed, I know, and you were appointed below in connection with the proceedings before Judge Ridinger, correct?
That is correct.
Yes, sir. Good to have you with us, sir.
Thank you. Good to be here. And may it please the court. I'd like to start in a little bit of a strange place, but that is the supplemental authorities filed by the government a few days ago. Because I believe that if this court does adopt the rationale from the Second and Third Circuit cases that he provided, that does change the argument in this case quite dramatically. Those cases that I'm sure you're familiar with said explicitly that the detention order or release order in a supervised release case, as this case is always pursuant to the authority of Section 3143 and never pursuant to the authority of 31.
And that's based on the rules. Those cases cite a rule. So if we did adopt that, we wouldn't just be following those circuits. We would be following the rules.
That is correct. It is certainly. I think that's a very rational way to proceed in this case. But that, of course, isn't the way that anything happened in this case below. So it makes it a little bit. I don't want to say difficult to argue, but it changes a lot of the argument in the briefing. For example.
So you do concede that if we follow Rule 32, that you have a very difficult time prevailing?
I don't believe that. What I do believe.
If we follow the rule?
No, I do believe if the rule is that every defendant, everybody on supervised release is awaiting execution of a sentence, and therefore that every release and detention order in a supervised release case is issued under 3143 rather than 3142, it does obviate our argument, one of our arguments, and that is the one that the order was issued in this case pursuant to 3142 and then somehow changed later. And that was certainly a focus of the briefing of both sides and all the argument in the court below. And I do agree that that is all largely made irrelevant if the rulings of the Second and Third Circuits are correct. However, there's an additional point to this part of this case which I think is made stronger by those authorities, and that is whether this order in this case was reasonably specific, which is an element of contempt, whether Ms. Jamerson had any real way of understanding what the order was.
Well, she was present at the hearing, wasn't she?
She was present at the November hearing.
And she sign the order?
She did.
Oh, okay.
And
So is that a claim that she had a lack of notice of some kind?
no, the claim is that because of the way that order was written, it would make it very difficult for really anybody to understand how the court was deriving its authority, but certainly would make it extremely difficult for someone like Ms. Jamerson. I think it's important to remember that Ms. Jamerson, leaving her limited intellectual capabilities aside.
Are her intellectual capabilities on the record anywhere? Or you're just saying that now?
Well, they were on the record in the district court. But
How? Where? Like, is it somewhere here that I can see that it says that she is of limited intellectual capability?
It was a significant part of our argument.
What-
We did not have her examined by a psychologist.
You didn't put any evidence Yeah.
We did not put any evidence.
So your
Okay.
record doesn't support what you're saying.
Okay,
I mean, that's,
okay, well, I was going to leave
you
that
can
aside.
argue based on the record.
Okay.
If you have some evidence to show that she was of diminished capacity and shouldn't have been allowed to go on the bond for her son because of
And-
that, I mean, that would be helpful to her for certainly.
That's
But-
correct.
But normally people go on the bond, they're responsible for having the person report when they need to report. That's what the bond's for.
Where the
And
argument.
Stay out of trouble with the law, and that kind of thing.
That is correct. But it is important to remember that Ms. Jamerson is not the defendant. She was the custodian.
She's the respondent, the separate proceeding, sort of a separate sub-proceeding. That's when you were appointed.
That's correct.
You were appointed to represent her when they started the contempt proceeding. This is a criminal contempt proceeding, correct?
Yes.
She's been adjudged in criminal contempt for failing to comply with her obligations to the court in the Western District of North Carolina in connection with her son, who was placed on bond. And she signed the bond. She's the bondsman, or whatever the proper terminology is. And she made her responsible.
The extent
That's the
of her
purpose of it,
response.
and that's what it was, and so they initiated a criminal contempt proceeding, and to give her proper process, gave her notice and appointed you. And you lost, and now you're doing your job, you brought an appeal for her.
I was not.
That's what this is.
I'm sorry, I didn't mean to interrupt.
Did I misstate anything?
No, but the argument that I'm making is I was not appointed at the time of the judge's order in November of 2023.
Let me
And
ask
what
you this, do you know if anyone ever, if probation or anyone explained to her what adverse consequences would be?
It's not in the record, but I know that it was not.
All right,
Well,
well,
I
the record
say I
doesn't
know
ref-
that it was not. She had
There's
told me it
nothing
was
in the
not.
record that reflects that she was told what adverse consequences.
There is nothing in the record to say that she was told, and in fact, I think the record is pretty clear that she was not told. For example, when the district judge, it was a magistrate judge that issued the original order. When the district judge did what we've been arguing about previously, which was we thought extended that order, but again, that order apparently, under the current logic, that order was pursuant to 3143 from the beginning. But when the judge told Mr. Jamerson at his sentencing hearing of all the consequences that could happen to him if he did not comply with the conditions issued by Judge Metcalf in his release order, which the judge did for Mr. Jamerson, he pointedly did not say anything to Ms. Jamerson. It's, as I argued in the brief, it's unclear whether Ms. Jamerson was even there. I will concede we don't really know whether she was there or not
Whether she was where?
at Mr. Jamerson's sentencing hearing.
At
We
the
do know
sentencing
she was
hearing.
at the detention hearing.
Right, we do know she was at the hearing where the judge said that he was to appear, and until then, the court said you are released under the same terms of the bond that you had been when you came here today, and there will be constraints upon you during that interim period. She was present at that hearing, correct?
We don't know that.
Really? Well, what hearing is it where the attorney said, Your Honor, his mother needs him, his mother is in the courtroom with his brother?
That was the hearing, and that one line is the
That is
evidence-
what hearing? The
Yeah,
hearing
what
you're
hearing
saying
is
she
that?
was not present?
The hearing, I'm saying I don't know if she's present.
Well, why did the attorney say his mother is in the courtroom with his brother? And that's one of the reasons that they were saying he needed to be released, because he needed to take care of his mother. The attorney said to the court, his mother is in the courtroom with his brother.
The attorney did say that, and she said differently, and that was never resolved.
You're saying now she's saying she was not in the courtroom?
She does not remember it. Now, she does not remember a lot. She is not an accurate
And I
reporter.
can't see, that's not in the record either, where she says she doesn't remember being in the courtroom?
That's right.
But the record's the record.
The record is the record. But at that hearing, were she in the courtroom, there is no doubt that Judge Ridinger, during his, I don't want to say lengthy, but not insignificant, conversation with Mr. Jamerson, telling him of all his obligations, what he had to do, going over the the provisions of that order. The judge did not at any point indicate that Ms. Jamerson was in the room, did not address her, did indicate that probation was in the room. The probation officer did not indicate that she was there or address her.
Well, this is her signature on JA 18, correct?
Yes.
On this document. She did sign Connie Jamerson, signature of third-party custodian, right below a sentence that says, "By signing below, the third-party custodian acknowledges that failure to comply may subject him or her to adverse consequences." She signed that document under that line that I just read, correct?
Yes.
And she did that in order to get her son out of jail pending his sentencing, and now does not, I mean, she assumed the risk there.
I presume that she did. I presume that her reasons are, as Your Honor says they were, although I was not involved at that
Well,
point.
it's what the lawyer said at the hearing. Part of the reason is that his mother needs him. His mother's in the courtroom with his brother. He lives with her and helps take care of her. That was part of the reasoning for him being released.
I have no reason to doubt that that's true. But that doesn't make the order any clearer as to what her obligations were. And if you read that order, well, I'm sure Your Honor has read that order, but
And it is pretty clear to me.
it does appear to be based on 3142, which apparently is not lawful. And if somebody who is not a lawyer just looks up that statute goes to the time where Judge Ridinger told Mr. Jamerson of his obligations under the order and said nothing to Mrs. Jamerson. In addition, the if convicted language, which was a significant part of the argument below, under the more recent interpretation of this release order being pursuant to 3143, the if convicted language is nonsensical, because everybody on supervised release under that logic has been convicted, and it is that crime of conviction which is the basis, the legal basis for the order of detention or release. And that's the basis of our argument, that anybody who just looked at that order that was done in this case, who's not a lawyer and did not
The
have-
one that she signed,
Yes.
okay. Could not understand when it says that the defendant is placed in the custody of Connie Jamerson, who agrees to supervise the defendant in accordance with the conditions of release and to use every effort to assure the defendant's appearance at all scheduled court proceedings, and to notify the court immediately if the defendant violates any condition of release.
And I don't think there's any evidence or allegation that before his trial or his supervised release hearing, there were any violations of conditions of release by either Mr. Jamerson, by Mr. Jamerson. He did show up for his supervised release hearing, and I don't believe there was any allegation that there were any conditions of release violated prior to that. The conditions of release alleged to be violated came up afterwards.
Right, and the court said at the hearing at which she may or may not have The court said at the hearing, until then, you're released under the same terms of the bond that you had when you came here today. That will be the constraints upon you during the interim period. And counsel said nothing more needed to be said.
That's correct. I will note that that particular evidence was not in evidence at her contempt trial.
The transcript that I just read.
Yes, that came up
Well, the
later
record
during.
was before the court, wasn't it? The record, the court had the record before it of the proceeding.
Well, it was the same judge. It was never mentioned at the
Same judge,
contempt
and
trial.
it's the record of the proceedings where she was on the bond.
Yes,
But your red light's on, you know what that means?
yes,
Okay.
thank you.
Mr. Gast,
Thank you, Your Honor.
good to have you with us, sir.
Thank you. Good morning. May it please the court. The order at issue here, when entered, made clear that the custodian's obligations extended all the way until, at least until her son, Stephen Jamerson, reported to serve his sentence.
But now opposing counsel says that Ms. Jamerson, who signed as custodian, is of some limited intellectual ability and didn't understand what the order said or that the order was continuing.
Yes.
At least that was what I took from his argument.
I heard that argument as well. I would say there's zero evidence of that in the record. There's been proffers, and there's been different proffers. In the appendix, page 95, it was during closing argument. It was not proffered as evidence, but during closing argument, Mr. Foster asserted that she had finished the 5th or 6th grade and was on some kind of disability for a mental incapacity. And that was the first it was ever mentioned, was during the sentencing after she'd been already convicted of contempt. Then in the opening brief, in an uncited footnote on page 13 of the brief, he said that she ended her schooling in 6th grade. Again, uncited, that's not supported by the record. And then in the reply brief, he asserted that she had a 3rd grade education, which that's the first time we've heard that. The truth of it is the record doesn't support any of that. There's
You're
no
saying that's an afterthought?
I can't speak to the motive for including it. What I can say is that she was present at the initial appearance hearing for her son, Stephen Jamerson, and Judge Metcalf, the magistrate judge, saw fit to release him to her custody. There was never any mention at that hearing that she didn't understand or she was incapable of being a custodian. And in fact, at the contempt hearing, Judge Reidinger asked defense counsel, how did the magistrate judge get this so wrong if you're saying that she didn't understand? And there was no evidence on the record to support anything other than what's evident on his face, which is this is a written order. The written order states all of the conditions. It's, by the way, it's our local version of the same order that's used in every courtroom in the country for release orders.
Let me ask you, I asked him the same question. Is there any evidence that anything was ever explained to her as to what adverse consequences meant?
I don't recall if there was anything in the record. So the only time that would have been mentioned would have been at the initial appearance hearing for Stephen Jamerson. I don't recall if anything was mentioned specifically about what adverse consequences meant. So I imagine not, given what's routinely done in magistrate court. But I would submit that doesn't matter because if we took that to its fullest extent, if we said that yes, that we would have had to explain what adverse consequences meant, then the natural consequence of that decision would be that every judge would have to explain contempt every time it issued an order and explained that if you violate this order, these are the possible consequences.
And what's wrong with that? I mean, she is unrepresented, right?
Well, certainly in a belt and suspenders approach, I mean, I suppose it would be helpful to explain that. But I mean, the courts give lots of orders, and so if the idea is that a court can't then enforce contempt unless it.
Well, I'm just curious as to, I mean, adverse consequences. What other than contempt? What other adverse consequences? are there?
I think that would be the only one, other than if the contempt escalated to, say, harboring, which then that could be another
Right,
criminal charge.
obstruction of justice, she could be indicted.
Sure.
Yeah, but that would be a separate, that you would be able to indict her for obstruction.
Correct.
Separately, yeah.
They could be
yeah.
fined, couldn't they?
Yeah, can she,
Yes.
yeah, what are the, so I guess that's my question, what are the other adverse consequences? Because it doesn't say what the adverse consequences are.
Right, and I would submit that this judge and judges across the country, issue orders all the time.
Is this the form that's used in all the federal courts?
Yes, this is the WDNC, was it 199? It's, yes, WDNC 199 is what we called it, which is the local version of the AO 199A and 199B.
So it's the Western District version.
It is, but it's identical to the AOC version in all relevant respects.
Is it identical in this respect that we're talking about here?
It is. It is. So there's no evidence before the court that Ms. Jamerson is anything but of ordinary or average capabilities. And the order on its face is clear. I mean, it puts him in responsibility for her son, not to make sure he doesn't violate any laws and make sure he shows up where he's supposed to. And the court found that she entirely surrendered all of those obligations, and found it on the basis of a very long interview where she talked about understanding so in her interview, she never said, I thought it expired. She never said, I didn't understand. She never said.
Which interview, I'm sorry, which interview were you talking about?
This is the recorded interview that was kind of the centerpiece of the contempt trial. So, so after Stephen Jamerson failed to report to BOP, I believe it was the following day, he was also on state probation. A state probation officer came, and that's when he fled. And then the following day, the U.S. Marshal Service showed up in force.
Fled from her house, right?
From her house. From
The
a
shed on her
out-
property.
That's correct. And so the following day, the Marshal Service showed up in some force, and probation showed up also to look for him, but also to interview her as the custodian. There was strong suspicion she was harboring because, of course, the defendant, Stephen Jamerson, was found in her vehicle.
Right.
And so one of the questions was, did she provide him that vehicle so that he could flee justice, which would be harboring, obstruction of justice, other crimes for which she could be indicted. During the interview, she said that he must have come and taken the keys without her knowledge, and we couldn't prove otherwise. So that's why the court proceeded in the contempt posture rather than indicting on contempt or obstruction of
And
justice.
this
or anything
proceeded
like
on a show cause order?
that. It did.
And was it something created by the court or by the U.S. Attorney's Office?
So the U.S. Attorney's Office initiated it with a motion. And then after that, there was some briefing, and then there was a hearing at the magistrate court level under 636. The magistrate court made some findings and recommended that she show cause to the district court, and then there was the contempt trial at the district court
When was
level.
the show cause order?
I'm sorry?
The show cause order was entered by the magistrate judge that initiated the contempt proceeding.
Yes, the magistrate court there was essentially the same hearing twice, that once at the magistrate level and once at the district court level. The magistrate judge also heard the hour-and-a-half long interview of the defendant and some other evidence, and then essentially, I guess, handled it as a sort of as an M&R of we're asking her to then go and show cause to the district court why she should not be held in contempt.
How often do you all have these criminal contempt proceedings relating to bonds out there?
Rarely.
Have you had one? You've been in the office for a while.
I have, about 24 years, and this is probably the third or fourth that I've seen.
Okay.
And these hearings are important. A lot of defendants can't get out on bond without having custodians. And we, the government and the courts also have to rely on these custodians so that they can give defendants that otherwise wouldn't qualify for bond a bond. And as Judge Reidinger said during the contempt hearing during sentencing, that a custodian is not a custodian if there isn't a consequence for failing to follow through with the duties. And so, and in fact, there was a long exchange between defense counsel and Judge Reidinger about this, about the consequence of being more strict about what's, she understood in this would be fewer releases from custody of pretrial.
But don't you think it would be better if it was more specific, even if the order says you can be held in criminal contempt? But just to say, there's adverse consequences.
Again, I think, yes, I think it would be better in a belt and suspenders approach if it'd be better to say that after every order. But, there's, like the
Well,
McMahon.
just because you have someone that's a third party, not charged with a crime, signing a form, in terms of, it's descriptive in terms of what she is supposed to do, but in terms of the consequences, if you do not do this, you can go to jail.
Sure, and different judges do this at different degrees. Judge King, you asked how many times this happens in our district. It's not very often, but so the magistrate judge in this case was Judge Metcalf, but his predecessor magistrate judge was Judge Howell. And I've appeared many, many times before Judge Howell. And when he once held someone in contempt for this very sort of thing, a custodian failing in their obligations. And thereafter, every time he put a custodian on a case, he said something to the effect of, I had a case once where a defendant's mother took custody of him, and I had to put her in jail because she didn't contact us when he violated. And I don't want to do that to you, but I will, so just take this seriously. So, some judges, set forth the adverse consequences more than others. And I will say, in terms of a case like this, is the the general deterrent effect is very real and very important in this case. If we don't have many of these types of contempt hearings because most of the time custodians do what they're asked to do. And when they start not doing what they're asked to do, and if word gets out, if defense attorneys can tell custodians, you don't need to worry about it since you're your mom, the judges aren't going to hold you accountable, then we're not going to be able to trust custodians. And if we can't trust custodians, then we're going to release fewer people on pretrial release.
The person that signs the bond, like here, the mother, is in the form referred to or defined as a custodian.
Correct. That's right. And the order really couldn't be clearer, perhaps except for defining what the adverse consequences are. But certainly what her obligations were very clear. Keep him out of trouble, and if he gets into trouble, report it, and make sure he comes to court, and make sure he shows up for his sentence when the time comes. And she didn't do any of those things, even though Mr. Jamerson, her son, violated in many ways. He was using drugs. He was not living at her residence regularly. He absconded from her supervision, and then took flight from officers, committed new crimes, and she didn't contact probation for any of those. She entirely abdicated her role as a custodian. And the system just doesn't work that way. And if we don't hold people accountable for failing in that way, then we're not going to be able to trust custodians, and therefore we'll be releasing fewer people on pretrial release. I don't have anything else unless there's any other questions to the panel.
Thank you very much, sir.
Thank you.
Mr. Foster?
Thank you. There has been a fair bit of discussion about the clarity of the order. And in fact, Mr. Gass just said that the order could not have been more clear. And I want to make clear in my argument that is, from November of 2023, when that order was issued, to February 1st, which was the hearing for his supervised release violation, that was certainly true, that it was very clear. But there were no violations then. What she was found in contempt of is for violating that order after February 1st of 2024. And that's where I think it becomes a little less clear for the reasons that I largely stated in the brief, so I'll just restate them quickly, I guess. But the order cites the statute,
But it's the same order and the same conditions, so how could it become less clear to the custodian?
I think a custodian who reads section 3142, should she have chosen to do that,
You said she's of limited intellectual capability, and now you want her to read section 3142.
no, I'm sure she
Okay.
didn't.
Right.
But the determination of contempt was the order clear enough to the person it was conveyed to? And
Well, the obligations didn't change.
the obligations didn't change according to, if you take the supervised release hearing, where the district judge said the conditions don't change, and said them at some length to Mr. Jamerson.
And then counsel said nothing more needed to be said. That's a quote from counsel, that the conditions would continue and be the same.
And that was conveyed to Mr. Jamerson. And if I were here representing Mr. Jamerson, I think everything that had been said about the clarity would
But
be.
you were saying they're not clear. They stayed the same. I take the point that mostly Judge Benjamin made, that what the consequences would have been to her for not following her duties as a custodian, that might not have been clear to her, but the conditions didn't change.
The conditions that put upon her were certainly clear. The time that those conditions,
Oh, so you're saying
Her-
it would be unclear to somebody who signed this that the conditions were still in effect,
that's right.
even when the court said the conditions are still in effect? Because you're saying she wasn't at the hearing.
She either wasn't at the hearing, but she
Even though
certainly
it's-
was not addressed at the hearing. I'm sorry, I didn't mean to
That's all right.
interrupt. But yes, the summary that Your Honor just gave of the argument as to what was not clear is exactly that. Certainly, the obligations that she had to do from November of 2023 to February of 2024 were clear. What we are arguing is that at the time she is alleged to have violated, it was far from clear that that order would still be in effect. It appears, as I said, that the courts are going to find that it was in effect. But this court has to decide in a contempt proceeding whether it was reasonable for her to know that. And I don't think, based on that written order, that can be proven beyond a reasonable doubt. So I don't have anything further unless the court has any additional questions. Thank you.
Thank you very much, sir. We'll come down and greet counsel, and then I'm going to exercise my discretion and take a brief break.
All righty.
This honorable court will take a brief recess.
Seated. In our second case, United States versus Lowers or Lowers?
Nico Lowers, Your Honor.
Lowers.
Yes, sir.
Mr. Tarleton.
Yes, Your Honor.
Good to have you with us, Mr. Tarleton.
Thank you, Your Honor.
You're going to
Great to be
explain
here.
all this to us.
I'm going to do my best. And I've reserved 3 minutes for rebuttal.
That's fine.
Here, no exception to the warrant requirement applies because the government, having the burden, never established that the files reviewed by humans at Google were the files that the detective opened and visually examined and used detailed information from in their search warrant applications. By doing so, the detective went beyond the holdings of the Supreme Court in Walter and
Now, at what point do you say things were done wrong?
At the point that the NCMEC cyber tip was given to the local law enforcement in Chesapeake, Virginia.
By what? By who?
NCMEC, it's a quasi-government funded nonprofit.
The National Center for Missing and
That's
Exploited
the outfit
Children.
that's got them from Google.
Yes, Your Honor. Google sends it to NCMEC, creates a cyber tip report
Yeah.
that goes to NCMEC. That's sort of this intermediary.
What do you call it, NCMEC?
NCMEC,
I
yes.
mean, we get these government acronyms, and I can't understand them.
Yes, Your Honor.
And I've been around the government a long time. So this is called NCMEC,
NCMEC, Your Honor.
okay? And
But you're not, go
And
ahead.
NCMEC sent them to a law enforcement agency.
That's correct.
Which they're required to do by law.
That's correct.
What's the if? Under what circumstances is NCMEC required to send them to the law enforcement agency?
The statute, Your Honor, 2258A talks about they have to make available to local law enforcement.
If what?
There's a parent violation of our,
Apparent
that's right, a parent violation is this,
violation of child pornography?
yes, Your Honor. Within the platform of an internet service provider like Google or Microsoft or AOL or Apple or
I'm just wondering
Facebook.
what the NCMEC obligation, and NCMEC here made them available to Chesapeake, Virginia Police Department.
Yes, Your Honor, made available, it's at J.
And was that transfer to making them available to Chesapeake a violation of the Fourth Amendment? In
No.
your view?
Making available is not, no, Your Honor.
Okay, so Google didn't violate the Fourth Amendment.
Well, they can't,
You
they're a
don't-
private actor.
You don't claim they violated the Fourth Amendment. NCMEC didn't violate the Fourth Amendment.
NCMEC didn't hear because if you look at J 93 where the cyber tip
Okay,
starts, NCMEC itself only looked at what humans at Google looked at. They did not, according to
now where's
cyber.
the requirement that humans need to look at it? Is that in some statute
No, Your Honor, that's a,
that I haven't seen?
it's not a statute, Your Honor. It's the
Well,
writ-
then it's got to be a requirement that you're saying that is.
the cons-
It
for-
has to be apparent child pornography, I thought you said.
for the report.
It has to be apparent child pornography.
Right, Your Honor.
And the determination here was made by Google by looking at and applying an algorithm that, according to Google, identifies the apparent child pornography. Correct?
According to Google,
Is
right,
that correct or not? Yes or no?
if possible, it
Well-
says possible child pornography, potentially, Your Honor.
It says apparent child pornography is what
Right.
they sent over.
That's right.
They sent it over as apparent child pornography.
That's right, Your Honor.
And their algorithm and human eyes had determined it was apparent child pornography.
That's not entirely true, Your Honor.
That's
Human
not
eyes
entirely
are,
true. Oh, what part of it is somewhat wrong?
okay, there's 156 files.
Isn't your problem that, isn't your argument that the law enforcement here went rummaging around and looking at images that nobody, no human and no algorithm had looked at before, and they did so without a warrant. Is that
Exactly.
your argument?
Yes, Your Honor.
And,
Thanks.
but that argument doesn't hold water if everything that Google sent over was looked at and identified by the algorithm as apparent child pornography.
And Judge King, I would agree with you if that were true, but that's not true.
Well, it is true.
Google,
Well, that's what it's, Google says, or the other brief says it's true, that, matter of fact, they say that the algorithm is accurate to something like 1 in 9 zillion times. It makes a mistake. Once in 9 zillion times, it makes a mistake. It's as accurate as DNA. And the courts accept DNA. And the issue is, they identified it. The algorithm identified it. There's nothing in the statute that says it has to be identified by a human being. But they say they identified it by human eyes before and confirmed it by the algorithm.
Well, let me ask you this, so, just so I'm sure, make sure I'm understanding, what, on the Google end, so they have this, hash match technology, and the technology, my understanding is kind of flags something that may be, I guess, suspicious, and then Google has humans look at the, a sampling, I guess, to see on that sampling if it is in fact, pornography. Is that how?
yes, Your Honor,
And I may be making it, I'm sure, a little more simplistic than what it is, but, and so here, there is 156 items that were maybe flagged by the hash match, right? Or 51 or whatever that number was, right?
that's correct. 156 files from Mr. Lawler's digital container at Google, his Google Drive account, were flagged by the hash value matching algorithm.
Okay.
Of those 156, only 31 of those files were actually opened up and reviewed with eyes by humans at Google. The remaining 100...
Now, were they looked at by eyes at Google before they were identified by the algorithm?
after they were identified by the algorithm.
So
as
you
Mr.
say
Lyle.
that there's 125 or something
56.
that weren't looked at by human eyes
Oh,
At Google, that's correct, Your Honor.
at
100
Google.
Right.
Just the algorithm. And there's nothing really in the record attesting to the accuracy or reliability of this Google hashing technology, is there?
That's right, Your Honor. The closest thing would be at J, I think 139. That's the declaration from legal counsel at Google that further explains the cyber tip report that goes to NCMEC. In that declaration, it's only a few pages. They outline in broad strokes how their hash value matching technology works. It's proprietary. It's different than, say, Microsoft's hash technology or Facebook's. Google's technology, and this is important to understanding the limits as to its purported reliability, it ultimately, the technology might say that the contents of one file is substantially likely to match the image contents of somebody else's file through the algorithm. But what it can't say is it's a virtual certainty that it contains an image that violates the federal definition of child pornography, 2256. The reason it can't is because it turns on human fallibility. The whole origin of the...
So that's the reason why they have actual human eyes look at to verify. Right?
Exactly, Judge Benjamin, yes.
Okay, so here, we only, other 156, only 31 were looked at with the human eyes.
Exactly.
Okay.
Yes, Your Honor, only 31.
and you're confident of those facts
Yes, Your Honor.
and you're confident that there's a requirement that the human eyes have to look at them.
That comes from, Your Honor,
It's not in the statute.
it's from the Supreme Court.
The Supreme Court says that? Human eyes.
Jacobson-
If the
Jacobs-
Supreme Court's reviewed this?
The Supreme Court has not weighed in on the hash value matching, but the whole origins of the private search doctrine derived from two key cases in the 1980s, Jacobson.
Private
and
search
Walter.
doctrine derives from Bordeaux versus McDowell
Right.
in 1921.
Yes, Your Honor.
There's the private search doctrine.
And Bordeaux is human eyes looking at
Bordeaux.
letters?
Well, that's all they had back then. They
Right.
didn't have computers.
That's right.
Right. But Google says there is reliable.
So the best analogy then, Your Honor, is it's an informant. And maybe it's a strong level of probable cause, but all it is probable cause to go
Well,
get a warrant.
if it's 1 in 9 zillion, that's a lead pipe cinch. It's not, it's a lot of probable cause.
Your Honor,
The district court says it was 1 in 9 zillion, and that's derived from material in the record.
Your Honor,
Didn't the district court
You don't
derive?
like that material.
Your Honor, it's, I don't condone anything that factually happened in this case as to like violating the law. But the point here is, no amount of probable cause. This is the Ninth Circuit of Wilson, the Second Circuit in Mayhere. No amount of probable cause creates an exception to the warrant requirement. Probable cause, you have to go get a warrant.
The private search doctrine from Bordeaux versus McDowell applies here because Google is a private party. And they're the ones that identified it. Your issue relates to what they sent over to this outfit. There's no question about that. What did Google identify, and whether it was reliable, whether it was probable cause? They did it, and the Fourth Amendment doesn't apply to Google.
And Your Honor, on this record, the Google's algorithm is not the functional equivalent of a human being weighing the
Well,
nuanced
that's
content.
You say that's on this record, and you're doing a good job for your client. I agree with that.
Like,
And I admire how much you have had to learn about this stuff.
It's a lot, Your Honor. This aligns with the approach by the Ninth Circuit in Wilson and the Second Circuit in Marr. Of course, there is a circuit
Yeah,
split.
and there's a Fifth Circuit case and a Sixth Circuit case that go the other way.
They do go the other way, and they are flawed, and the Ninth Circuit and the Second Circuit are better because a detective, a human being visually examining a...
So we're dealing with a straight-up circuit split.
We are, yes, Your Honor.
They'll make a Supreme Court lawyer out of you with this case.
Well, I just want to get through this court.
So, speaking of this court, assuming we were to find a Fourth Amendment violation, how do you get around the government's, if you can, attenuation argument that this is so many steps removed from, we start with Google and go here and go there, and it's, several steps before we finally get to your client?
Yes, Your Honor. I think that those exceptions, attenuation and good faith, don't save the government from the operation of the exclusionary rule here because, first, under this prism, an important prism, the government has the burden, just as it does to establish an exception to the warrant requirement, it has the burden to establish the operations of the exclusionary rule. Here, the
There's some
government...
disagreements here about who has what burdens, I think, aren't there? Between you and the government?
The district court put an initial burden on us to establish an subjective expectation of privacy, but beyond that, the law is clear. Coolidge versus New Hampshire and Nix v. Williams, Supreme Court, the government has the burden to show that there's a narrow exception to the warrant requirement exists. And just as this court in Stevens, as well as Seidman, applying exceptions to the exclusionary rule and good faith doctrine as well, the government bears these burdens to show the exclusionary rule shouldn't operate. So here with attenuation, Your Honor, the government...
But we don't get to attenuation or good faith unless there's a violation of the Constitution.
That's right, Your Honor.
Right, and I
That's
just
right.
asked him to assume that there is, how can he get
Right.
beyond attenuation?
So here, Your Honor, Wong's son and this court in Seidman and Stevens are examples cited, and Your Honor was on the dissent on Stevens, but there's an important principle. Well, actually, as to attenuation, we look at Seidman. The government's chief argument, I think, is other than passage of time, and this court has also said that there's no magical amount of time that passes to create attenuation. But other than passage of time, Mr. Lauer's consenting to a search of his phone when the detectives came to interview him after they searched his parents' house in Virginia, and they interviewed him in North Carolina, hence why this case comes out of the Eastern District of North Carolina. When they interviewed him, he gave consent, but the problem with the district court and the government's analysis is free will, an exercise of free will under the Fifth Amendment standard for what's a voluntary confession is different than the Fourth Amendment exclusionary rule that they have to prove doesn't apply, which is a stricter standard. It derives from the Supreme Court in Wong's son. Did the police use some kind of
You would have to say that there's any evidence of coercion, right?
not under the Fifth Amendment, Your Honor, but the Fourth Amendment analysis is different. They have to prove, and they disavowed an evidentiary hearing below. That's at J 234. They have to prove that they didn't use information from any unlawful search in questioning the suspect that could have influenced the suspect's decision to get consent. And here we know that they were questioning him and they relied on what they obtained from Google in their first search warrant to get the contents of the Google account after they already did the warrantless review of the photos or images. Then they, using that information along with information from a warrantless search, they got a search warrant for his parents' house. And from there, they did forensic examinations on devices electronic devices at his parents' house, as well as interviewing.
So how many Fourth Amendment violations are you claiming there were of that? Half a dozen?
A fair amount, because they kept on repeating the Fourth Amendment violations in every single warrant that they got, and that's the.
But they started with this outfit that, whatever the acronym is, sending it to Chesapeake.
They started, Your Honor, when they got it, and then they went beyond just the report. They double-clicked and opened the files, and those are digital containers.
Which Google had said are apparent child pornography.
Right, under unknown standards that Google uses to train Google reviewers. They're not law enforcement officers. And 2256 shows that the definition of what constitutes child pornography is incredibly broad. There may be extreme cases of certain images that clearly are, but that statute is so broad, it talks about any image of somebody under the age of 18 who's nude and may be giving a lewd or lascivious exhibition, or things that are very debatable and highly
Are
subjective.
you claiming that the algorithm doesn't take that into account or something?
Not only does it not, it
You're
can't.
claiming it's flawed or some way?
The algorithm does not even purport to analyze apply the federal definition. All that, the algorithm really answers the wrong question. It says,
So you attack the algorithm, you don't
Yes,
trust
Your
it?
Honor.
Okay.
yes, we can assume it's reliable, but it's reliable answers this is the Ninth Circuit's reasoning.
It's not foolproof.
It's not foolproof. And here we have a even more deficient evidentiary record. There was no experts offered by the government under its burden to prove up the high reliability of it. But even you could assume it's highly reliable. It's
Are you saying there ought to be it should have been an evidentiary hearing of some kind?
we had no burden. The government had the burden, and they disavowed.
You don't answer my questions very often, but are you saying that they need to have a hearing?
We say no, not now, Your Honor. They should have been.
I didn't ask you that. Are you saying they should have had a hearing?
They should have to carry their burden, yes.
You're saying
Well,
they should have put forward,
If you just listen to the question, you can answer it. I
Yes, Your
know.
Honor.
But you answered another question that you wish you'd been asked.
Yes, Your Honor.
And I don't blame you. I mean, they must teach a lot of these lawyers that in law school. But we want some people to come down here, that we want them to be straight with us.
Yes, Your Honor.
But there was no hearing, and no one requested one.
That's correct, yes.
That's right. That's what the record shows.
Yes, Your Honor.
And because of that, you're saying that because the government did not have an evidentiary hearing to meet its burden of proof with evidence sufficient to show that this was reliable, this technology, then you should prevail.
Yes, Your Honor.
Okay.
And likewise, Your Honor, they haven't met their burden to establish attenuation or the good faith principle, that there was no binding appellate precedent when the detective authorizing this warrantless search and examination of those files, when the detective in early 2020 opened those files and examined them. There was no exigency. In fact, they waited months before acting on the cyber tip. There's no evidence in the record of a legal opinion from the U.S. Attorney's Office saying that this is a valid warrantless, exception to the warrant requirement. There's just nothing that fits the traditional good faith.
Well, only that Reddick opinion was out there at the time.
That's right. There was Reddick in the Fifth Circuit, but there were sort of contrary strong signals from Ackerman in the Tenth Circuit. So there was no strong body of law that would have provided the detective objective good faith under the legal principles for the good faith exception to rely on.
Wouldn't that help? That helped him in terms of their argument? That he wasn't out here just, that he had no direction other than this Reddick case.
Your Honor,
They said that it was okay.
but
And which is, I know it's not binding in this circle.
that's right. That the test really is their binding precedent. And so if you look at the Stevens case, the Stevens majority opinion cited, and that case dealt with tracking a car with with GPS right before Jones came out in the Supreme Court and said that's unlawful, you need a warrant to do that. And the Stevens case, they said, well, you had this Knott case from the Supreme Court that authorized electronic beepers in containers, and so that's the binding precedent that would create good faith. Here, you don't have that. You have a non-binding decision in the Fifth Circuit, that's it. And so the only thing else that the detective could look to objectively would be the Supreme Court's case in Jacobson in the early 1980s, where FedEx employees looked inside a box and discovered cocaine. And that is nowhere near analogous to an algorithm where no humans are looking at the contents of the file. That wouldn't provide good faith, Your Honor. And then, again, going back to attenuation, every warrant that was obtained in this case ultimately relied on information, detailed information, either obtained through a warrantless examination of digital files or the contents of a prior warrant that was obtained by relying on the warrantless examination of digital files. And the government hasn't proven that. This is important under Seidman in this court, that attenuation doctrine for the government to prevail, it's supposed to be a careful, nuanced sifting of the facts. It contemplates a robust evidentiary hearing that would take place to establish the attenuation doctrine. See that I'm out of time?
Yeah, you have been out of time here for a while. But that's all right. You answered a lot of questions, and we really appreciate your work in this, and I really appreciate you coming in here as a court-appointed lawyer and handling this.
Thank you, Your Honor.
And Ms. Brown, we'll hear from the government.
Good morning. Lucy Brown for the United States, and may it please the court. The government has 4 independent bases to affirm here, 2 substantive and 2 prudential, but any one of those is enough. I want to start substantively with whether a Fourth Amendment search even occurred. The defense counsel said several times that we, the government, were the only ones with a burden. But he has an initial burden of showing a reasonable expectation of privacy, and he cannot do that for his Google account. Getting this Google account, you agree to terms of service that say we might look at your account for child pornography. Google has said, as a business, we don't want to be a safe haven for child pornography. So-
Right, it said we may look at, the affidavit says we may look at your account for child sexual abuse material.
The terms of service say that. The privacy policy says that they will look for illegal content.
What did the affidavit that the court used that was argued in the district court, what did it say? May?
So it's a little confusing because
I
Google.
think may's enough.
I would have.
I think may means that they're entitled to.
I agree, Your Honor, and I think it certainly reduces.
I may do it. That's right. I'm entitled to do it.
I agree, and I think it certainly reduces an expectation of privacy, which is the question. To Your Honor's question, Judge Thacker, the affidavit says we may, meaning she as the affiant is writing that, and then it begins quoting the privacy policy that says examine your content for illegal content, but the actual privacy policy itself says we will analyze. It does not say may when it says that in the privacy policy. That was the affiant's may in the affidavit, which I agree is a little confusing.
Is it possible to have a right to privacy in contraband?
No.
And child pornography is contraband?
Yes.
It's absolutely prohibited.
Yes.
It's a crime to possess it.
Yes.
So that's where the government starts.
Yes, Your Honor.
You can't have a privacy right in contraband.
Yes, Your Honor. And in that's exactly what Google is saying too, that we don't want this here. We will search for this. We will search for it in a way that we will only detect child pornography. We will not be, this doesn't alert some of those Fourth Amendment concerns that defense counsel mentioned in his brief. They're not seeing innocent material. They're not getting into the contents of your emails. They are looking for this thing that both the government and Google has said you cannot store here. And he did not meet that reasonable expectation of privacy.
What about Riley and Carpenter and this whole evolution of technology and those lines of cases? How does this square up with Riley and Carpenter?
So they're different in some important ways. One is we have the private search component here. This isn't a government process. This is someone else gathering that information and providing it to the government. And as Judge King mentioned, since 1921, that's been a well-established practice that does not violate the Fourth Amendment. So that's one, and that's a major one. I'm sorry?
Google and the internet hasn't been around since did you say 21?
Private search has been around since
Right.
1921.
So, I mean, the Supreme Court has said that the internet is a whole different creature here, haven't they?
I'm not sure how to answer that. I think in some ways, of course, we're dealing with something different. I think hash matching technology is unlike anything in the analog world. But I think in other ways, they have tried to map on those analog practices to this new digital world.
And I have a question about the hash matching technology, but I don't know if you answered Judge Benjamin's question before I jumped in there, so go ahead.
Thank you. So the one component of that is the private search doctrine, that this is different. This is someone else gathering this information. The other part of that is the information that they were gathering in those cases is purportedly innocent information that you have a privacy right to, which is also different here where we're just talking about child pornography. So those are two differences to those cases that you asked about, Judge Benjamin.
So you think, what is it, Cabela's, isn't that the case that says if it's contraband, then you have no right to privacy?
I don't think you have a right to privacy in child pornography. And I certainly don't think you do if you're uploading it to a Google account that has told you, hey, we're going to be looking for this. I think the defendant knew that. That's why he registered it under this alias, Harvard Epperstein, and put no personal information. He had a personal Google account. He didn't use that for his child pornography.
And that account was lasted for what, 30 minutes or something?
That's right, Your Honor. And this was the only.
And there was nothing in the
That's right.
account except child pornography.
That's right, Your Honor.
It wasn't used even once for some legal purpose.
That's right. It was exclusively this, and I think that shows the defendant did not expect privacy in an email account. That's why he tried to make a separate one. That's why he didn't use the one linked to his name and to his private information, because he knew he was taking some risk doing this. And that's enough. That shows he didn't have that reasonable expectation of privacy. And we're dealing with a Google account. This isn't like your home. This isn't like some of the sort of nightmare scenarios that defense counsel mentioned in his brief or the Ninth Circuit mentioned in Wilson. This is not like a search of law enforcement in your home. This is like a search of a storage unit proprietor.
It's more than just your home. Your Google account, it could have more than you have in your home. It's more invasive.
I'm not sure I agree with that premise, but I think one key difference is by the nature of a Google account. I'm not talking about the material that's in it. Certainly it can contain sensitive material. That's not what that's not what they're looking for here. That material they don't see, that is safe. But
And where in the record can I look to find the information about the reliability of Google's hashtag technology?
And I understand Your Honor's question, and I think it's, we did not have a
You
hearing.
understand it because it's not in the record.
I'm not sure it's not in the record. It could have been developed further.
Well, so where is it then?
We talk about in our motion, we talk about how hash matching is
In
the
your
equivalent-
motion? So
I'm
it's
sorry,
an
our
argument?
response, Your Honor.
But so it's an argument, it's not, there's no evidence? It's just an argument?
This is where I'm trying to clarify. In our response in the district court, we talk about a hash match and using it as almost like a digital fingerprint, that if they've seen it before, they assign a number.
Right,
and they
I
have
know,
one now.
and what do you cite to support that?
The fact that there
Case law
wasn't,
or an expert?
there wasn't a dispute about the facts in this case. The district court understood them to be stipulated to. So I think what defense counsel has
So you're saying that appellant stipulated to the reliability of this hashtag technology?
I'm saying that is what the district court found, and I think that's right. I think what they have contested is the protocol at Google, that they don't know how those determinations are made. I don't think he has ever, nor could he ever, say that the hash matching technology itself is inaccurate. And I think that's the key difference here. Because that, and we're in private search land here.
And when you say, you're saying appellant has never
Yes.
said that the hash matching technology is inaccurate,
That's
even
right.
though it could be?
I think it could be to 1 in 9.2 quintillion, yes.
So
And
we
that's-
have to take them as accurate.
I would certainly think so. That's the best odds I've ever heard,
And Judge Myers accepted them as
Certainly.
accurate and having been stipulated to.
certainly. And I think any questions
And
they've,
that stipulation is not contested on this appeal.
the accuracy of hash matching, I do not understand to be contested.
And
no.
where is it that appellant stipulates to the accuracy of hash matching?
That was Judge Meyer's conclusion based on reading the two briefs. And
No,
I-
but so where in the brief did the appellant stipulate to the hash matching technology?
They weren't styled as stipulations. What Judge
Right.
Myers concluded is these are, the facts presented are not materially different. I think what they are contesting is not the accuracy of hash matching. What they are contesting is how does Google use this technology in making those determinations about if something should be considered child pornography. But that is of no moment when we're talking about private search. Private search does not care if you get that initial determination right. Private search only cares about if what the government actor is seeing is what the
But
private actor
Google only
saw.
looked at 31 of the child sexual abuse material images, and law enforcement then looked at others outside of that 31. And that's their issue, and they did that without getting a warrant, which would have been exceedingly easy to do, especially after all these years, but they didn't bother to do it.
They did not do it initially. They did do it eventually.
Well, they didn't do
I
it
thought that
before
the-
they looked at the images.
It's in
That's
the-
when you
It's in the brief
get,
here that every one of them were looked at by Google employees.
Your Honor, yes, that is the only way there can be a hash match.
not every one of them, 31 of them were opened.
On these facts, in this case, 31 were
Right.
opened.
But
But
the
the
only
everything-
31.
Everything that has to do with the hash match has been looked at by a person.
yes, the 156 have all been seen by Google before.
What do you mean
156
see-
had all been looked at by human beings.
Oh,
Yes.
before in some other case. This is what you're talking about.
Yeah, that's how they get in that
No, I
hash match
understand how they
repository
get.
to begin with.
I understand that. But in this case, the case we're talking about, Google only opened 31 of the images, and that was the report they made
Yes,
to law enforcement.
yes,
Who
And all
then
31
opened
were
additional.
Child pornography.
yes, Your Honor. All 156 were.
All 156
Well-
were child pornography,
What,
according to Google's hash matching.
Yes,
so
So
why
there's
does,
no error whatsoever,
yes,
according to the Googling on this record.
yes.
so why does Google, if we are to rely solely based on the hash matching in the 156, why does Google have employees, I guess, human eyes look at the 31? Isn't it to verify that that's what it is?
I don't know their thinking. I think they certainly do review those items. Yes, Your Honor.
Well, it's exactly what Judge Benjamin said. I thought the briefing said that that's why Google looked at it, to verify that it was child sexual abuse material.
I'm sorry, I don't understand I don't know their
Isn't it-
motivation. I think that is what they're doing, yes. They are opening those, confirming that it matches.
What, well, do you have
What
a
the-
follow-up question?
Because they want to make sure that what they're reporting is reliable.
Yes.
Right. Okay, because they don't want to solely, to me, it seems as if Google is not solely relying on this hash match, the 156, and they have to go in and verify the 31 to make sure that the algorithm is correct, because it's just the algorithm, right?
I think, to use the term from earlier this morning, that is a belt and suspenders approach that they have adopted. Yes, Your Honor. They have the hash match, then they review those images, yes.
And how accurate is the algorithm?
My understanding from that hash matching itself is more than 1 in 9.2 quintillion, I think was the number.
And your understanding comes from what expert in the record?
There is not, Your Honor.
Yeah.
How'd you get it in this record?
Judge Myers, in his order, relied on secondary sources and other cases that discuss the reliability of hash matching, of which there are many.
And were they submitted by the government?
They were not, all Your Honor. The other component of things is Fourth Amendment issues aside, and I understand these are complicated issues, but in this case, they don't even need to be decided. I think the government should prevail on them, but they don't even have to be decided. And even if the court finds there is a Fourth Amendment problem, we have two prudential avenues to affirm this case as well. One being attenuation, and opposing counsel said that our chief argument, other than passage of time, there is no chief.
Before you get to that, I can't, you just said that the district court relied on other cases and facts in other cases for that statistic that you just put out there without an expert in the record. Is that correct?
I don't remember if that statistic came from another case or a secondary source, but yes, Your Honor, it was not submitted by the parties.
All right. And doesn't our Fourth Circuit case, Zayad, Zayyad, say that facts adjudicated in prior cases cannot be used in that way?
I have not reviewed that case before today, Your Honor. I
Okay.
certainly trust your understanding. Even if we have a Fourth Amendment problem in this case, and the government, of course, argues that we do not have an affirming problem in this case.
If the government has a Fourth Amendment problem, where does it start?
I think the only Fourth Amendment allegation that they have is that the Virginia detective opening the images sent by Google.
This is the Chesapeake Police Department.
Chesapeake.
Opening the additional images that nobody at Google had confirmed prior.
From this time.
Right.
Yes, Your Honor.
Are any of those, there were three of them, are any of those three being used against this defendant?
There were at least 3, and no. Those are not none of those images are what the defendant was indicted for. None of them in this case. Which brings me to our
You
attenuation.
mean the 3, but the warrant does reference the images in the 156. That's how he was able to get the initial.
I think that's what Judge
Evidence.
King was asking, that she reviewed at least 3 outside of the 31. They're all from the 156, unless I'm misunderstanding your
That's what
question.
I was
But she-
getting at, but whether they were used to indict him.
No,
But
None of the 3 were used against him.
that's right.
But the description she gives doesn't say what she used out of the 156, right?
It has the hash match itself, and that's how they, I think, tried to check that against the list and discover that they were not of the 31 that Google had opened. I'm not sure I'm understanding your question.
So I guess what I'm asking is, so we don't know the description that she gives, we don't know if that's in the 31. We don't know if that's in, we know it's not in the 3. Or is it somewhere out here in the other, I guess, my math is not good, but whatever the other 120 something. We don't know, that description is not, we don't know that it's in the 31 that were reviewed, right?
The ones that she has listed, there's 1 in the initial warrant, and there are 3 in another. And I don't think any of those 4 are from the 31, based
Okay.
on those numbers.
The ones that were reviewed by Google.
That's right.
Okay.
I don't think that's a problem for the reasons in our brief, but that's my understanding of the facts, Your Honor. And I think to Judge King's point, none of those 156 are the images or files that the defendant was indicted for and pled guilty to. And that makes this case very
Because you
different.
pulled those off of the devices that he turned over.
That's right. After giving his consent, giving an interview, providing his device to be searched, then they found 4 new images. And then those images were put in a warrant.
And I understand that as your sort of attenuation argument. It's so
Certainly.
many steps and years down the road. What is your good faith argument?
The good faith argument is that at this time, when Detective Ryder opened those images, she was reasonably acting in what she believed to be a constitutional way.
Based on what?
The
Based
only-
on what precedential authority?
And we do not have a precedential authority
Okay,
here,
well,
Your
then
Honor.
that's how good faith works.
I'm not sure that's the only way good faith works. I think in the Davis case, the court talked about other expansions of the good faith policy to include a reasonable law enforcement mistake. I think in the case they mentioned there, it was reliance on a database that had some mistaken information.
So what was the reasonable mistake?
If her looking at it was a mistake, our position would be that was reasonable because she did not think she was acting in an unconstitutional way.
Based on what? What binding appellate precedent specifically authorized this search?
And we do not have a binding appellate precedent. What
Okay.
we have is what her mindset would have been and what the way she was acting. And I think
That
there's,
she had been, it indicated to her that these were apparent child pornography
yes,
determined by Google,
yes, and that the,
which was absolutely true.
yes.
So
And the
that then
only-
she should have gotten a search warrant to look at
True
the rest of
beyond her
them.
adventure, that Google had made that determination.
Google had made that determination. The only published opinion in the country at that time said that this was acceptable. That is our good faith argument, Your Honor,
Said that what
That's
was
the Fifth Circuit?
acceptable.
opening these documents.
Has it since, and there's been case law since, that this was not acceptable?
There's one opinion since that says it wasn't. The Second Circuit, which went against us substantively, actually found good faith for that very reason, for saying that at the time, the one appellate court that had weighed in had said, and this was the Fifth Circuit Reddick opinion, had said this was okay for her to do. We think that shows good faith. But I think getting back to attenuation, defense counsel characterizes our chief argument and mentioned 2 out of the 3. There is no chief argument in attenuation. The government has strong standing on each of those 3 arguments for attenuation. We have temporal distance of 6 to 7 months. We have intervening circumstances, including the quintessential act of free will, which is that consensual encounter, consensual examination, a search warrant for his home, looking at an item he directed us to. And the one that's considered particularly important in Brown, the case where agents are waiting for a defendant with guns drawn inside his home, we could not be further from that in this case. So this, even if the Fourth Amendment issues are complicated, even if we lose, this is an excellent case for attenuation. The government meets each of those prongs decisively. And for all the reasons in our brief, we would ask that this court affirm.
Now, what, you said there were 4 ways you could win.
Yes.
Did you ever list them in order?
I'd be happy to. So substantively, the way they are in our brief is there was no Fourth Amendment search because there was no expectation of privacy. The second one is this was a private search. Then our prudential arguments are, and I think in the order in the brief says good faith and then attenuation.
Okay. Now, if good faith or attenuation work, why do we rule on a constitutional question?
You don't have to.
Did you ever, you familiar with Ashwander?
Familiar, yes. Could I discuss it with you right now without having read it more recently? I'm afraid
Well,
not.
the principle of Ashwander is that a court shouldn't address and resolve a constitutional question if the dispute can be resolved on a non-constitutional basis.
Yes, Your Honor, and that's what our introduction in our brief says. You
And
don't
that
even
would-
have to get into this.
That would mean that if the government acted in good faith, we'd go right to it.
That's right.
But that wouldn't help the situation here with circuit split and advice to the parties and Googles of the world
It wouldn't develop.
about private searches and the like.
It wouldn't develop that. It would decide this case. And we would ask you, for whatever basis, we have 4, each of them is sufficient. We
And
would-
you also say that there might be a need for a hearing.
If none of those 4 persuade the
No,
court.
but you say that.
Yes.
In your brief, that's right.
Yes. If none of those 4 persuade the court, I think the record does suggest that the detective looked at all 156.
Would you put an expert on the next time, if you got a hearing?
We would follow the terms this court set for a remand.
No,
if
what I
the
was
court
going
did that.
to ask you about that, if there was a hearing, what would they be the issues that you would propose needed to be determined?
What we have said,
You don't tell us that. You just say that an evidentiary hearing.
I do think I tried to say that, but I'm happy to have a chance to
Okay.
clarify if that didn't come across. What we are asking specifically is a hearing to determine if Detective Ryder in Virginia actually looked at all 156 images, which would necessarily include the 31 that Google viewed. I think the record suggests that she did. And so I think defense counsel has recognized that if she did, that severely undermines his argument. And that, I think the district court did not make a decisive finding on. The district court
I
said.
thought you would want a hearing or determination of the accuracy of the algorithm.
I think that would certainly be in our interest, but I also understand that we would follow whatever restrictions the court put on a remand. The factual
No, I'm
issue.
asking for your advice. We need the lawyers, if we're going to talk about it, asking for a hearing, an evidentiary determination, we ought to have both sides weighing in.
Sure.
On what we would ask the district court to do.
If we had it to do again, I would recommend that we bring an expert about the reliability of hash matching. If the court has concerns about that, as I understand that it may, at least members of the panel may, I think the narrow factual issue that we put in our brief about developing whether the Detective Ryder looked at all the images, which would undermine their private search concern, because it would necessarily include the 31 that Google had viewed. I think that is something that was put forth on the record and the district court did not make a conclusive finding about. Unless there are any other questions? Thank you for your time. We would ask that you affirm.
Ms. Brown. Mr. Tarleton?
Thank you, Your Honor. At Joint Appendix 277, this court will see that Mr. Lowers did not stipulate to the reliability of Google's hash matching proprietary technology.
What'd you say, 277?
Yes, Your Honor. It's Mr. Lauer's reply to the government's response on suppression. There, it was stated.
And that was in the district court.
That's right, Your Honor.
Did you raise that point with the judge? It's indicated in his opinion. Did you raise that he was wrong in saying you had stipulated?
Has this been preserved, this issue? Was
No,
it raised,
Your
or is
Honor.
this, or is it up here now? You're raising it now for the first time?
She raised it,
The government.
and it's not accurate.
No,
not accurate.
the district court said you stipulated, and then Ms. Brown said the district court said you stipulated. Now you're saying you didn't stipulate. Had you raised the point that you say you haven't stipulated with the district court?
To answer your question precisely, no. That said, Your Honor, the district court did not say we stipulated to the reliability of Google's hashing technology. The district court's note.
Oh, the district court didn't say that.
The district, right,
You
everything,
say Ms. Brown is wrong.
That's correct.
that it's inaccurate. The
Okay.
district court did not, am I correct? The district court did not say that you stipulated. The most the district court said is that the recitation of the facts appears similar, or something like that, and she takes that to mean it's a stipulation of some sort.
I think you used the
Judge
word
Thacker.
stipulation. My
Yes, sir.
recollection.
Judge Thacker, the stipulation is the first footnote in the district court's order denying suppression. The district court says, essentially, there's a stipulation between the parties as to material facts.
Right.
That's all that says.
There you go.
Right,
Right,
That must be what I'm remembering.
right.
That's right.
There's nothing about it, but, okay, go ahead.
the district court went on to then, on its own, bring in case law and law review articles on hash matching technology. But this is what I'm getting at, important as to.
Because it needed to fill in the gap that the government did not put in any evidence to support the reliability of that technology.
Exactly, Judge Thacker. What Mr. Lowers last said to the district court before it ordered was, in his reply, 227 in the JA, Mr. Lowers certainly maintains Google's proprietary technology does not render a virtual certainty that two files are the same. The analysis in Wilson hinges on that fact, as in this case. Google does not keep a repository of child pornography images, so no Google employee could have shown the government the images it believed to match Wilson's, nor does the record identify the individual who viewed those images in the repository, so no identified Google employee knew and could say that what those images showed. That,
And that was in your brief before the district court, so you,
that's correct. Furthermore, the government here says Mr. Lowers doesn't have an expectation of privacy in a Google Drive account. That is synonymous with a Gmail account. That's
Well, can you
email.
have an expectation of privacy in contraband?
No, no one has an expectation of privacy in per se contraband. No one does, Your Honor.
No one does.
Right.
And child pornography is per se contraband.
It is, Your Honor, yes.
So you can't have a right to privacy in child pornography.
but if you have child sexual abuse material in your home, in a drawer, you have a reasonable expectation of privacy there, correct?
Exactly.
And if you have child sexual abuse material in your Gmail account, in a drawer in the internet, your argument is you have a reasonable expectation of privacy there.
Exactly, Your Honor. You don't have an expectation of privacy in a brick of cocaine, but you have an expectation of a privacy in a closed book bag that may ultimately reveal a brick of cocaine. That's the digital containers, papers, and effects that the Fourth Amendment protects, that the trilogy of Supreme Court cases, Riley, Jones, Carpenter, all extend traditional Fourth Amendment expectation of privacy doctrines into the world of digital files and digital containers. Every circuit that is confronted, well, no, more importantly, this circuit in this court, Zelaya Valiz, said that there is a Fourth Amendment expectation of privacy in your private Facebook messages. That's a social media account. Those work similar to email. So if you have, this court has foreclosed the government's argument, and every circuit to confront the government's argument head on. Mayor in the Second Circuit, the Sixth Circuit in Warshak, 10th Circuit in Ackerman, every circuit, Wilson, in the Ninth Circuit have refuted this idea that you don't have an expectation of privacy in email just because it exists on a cloud server. So that shouldn't be any basis to not reverse the district court's order. On attenuation, I think maybe the biggest prism to think about is the government has the burden of proof to show attenuation. Seidman, this court talks about how that is a careful sifting of facts, nuanced facts even, and that didn't where they have the burden, that didn't happen here because they told the district court at JA, I think 234, every issue here is a matter of law. We don't believe an evidentiary hearing is necessary. And so now they are seeking to have a redo. If the evidence is insufficient in a case, this court doesn't traditionally remand for a new trial. They shouldn't do so here.
Well, there had been a trial.
By analogy, Your
It
Honor.
wouldn't be a new trial, it'd be a remand for a hearing, is what she said.
Given an analogy, but
I mean, you haven't indicated any position previously on that.
I understand, Your Honor, that they have not cited any case to this court that I know of that says after the government below said we don't want a hearing, when they realize they're in trouble on appeal, now we need a hearing.
We need a do-over.
We need a do-over. No, they have not advanced a case to this court supporting that proposition. Finally, I think Judge Thacker, you said getting warrants.
Have you ever heard of Ashwander?
No, Your Honor.
You heard the discussion of it.
I did, Your Honor, yes. Getting warrants is not a heavy burden. In fact, Riley, the Supreme Court talked about in the digital age, it's actually easier than ever to get a warrant. You can communicate electronically with judges. Probable cause is only a fair probability standard, but it's an important standard. There has to be judicial constraints on law enforcement's ability to sift through the vast troves of sensitive data that exists in these digital platforms. And we are reminded of first principles from the framers, and this is identified in Carpenter, that it is actually a central aim of the framers to place obstacles in the way of too permeating a police surveillance. That is the whole foundation of the Fourth Amendment jurisprudence. It didn't happen here. They should have gotten a warrant, and everything that flowed was tainted, Your Honor. Thank you.
Thank you very much, sir. We appreciate it. Again, we appreciate your work.
Thank you, Your Honor.
And we're going to come down and greet counsel and then go to the next case. In our final case today, we have the United States against Nathaniel Martin. And Mr. Coleman, you represent Mr. Martin?
Yes, Your Honor. Good morning. May it please the court, with the briefing, my estimation, the final decision in this case comes down to one passage out of Rodriguez. Rodriguez does say that officer safety interests stem from the mission of a traffic stop, and that they are especially fraught with danger to police officers. That's well accepted in the circuit. This court recognized it even in Palmer. But Rodriguez also says that on-scene investigation of other crimes detours from that mission, and so too do the safety precautions taken in order to facilitate such detours. My submission in this case on behalf of Nate Martin is we're in that second part of Rodriguez. I recognize what Palmer says, but in this case, it initiated with the gun investigation. The parties in the vehicle had already engaged the forestry officer 45 minutes before what's been called the second stop in the briefs. They knew his authority or claimed authority. They recognized him. They conversed about what was there. He testified. He told them not to park on the side of the road, even though it wasn't in his narrative report. He came up on him again after routine patrol on that road in the National Forest, after telling them they could have a gun there. And West Virginia's constitutional carry now under 6177C. So when he learned at the very beginning, the first question, which really do we want to ask in every traffic stop, you know, great, she had a gun, it was under her seat in the car. He didn't pursue that any further except to ask her 4 more times after she answered him, while she was getting her license and getting her registration and her insurance documentation, which he did not even investigate. He said, gosh, I'm out in the woods, it's hard to call any of it in. So he was going to be satisfied just looking at the insurance and the registration. He got that less than 3 minutes into the body cam video. And then he spent the whole duration of the stop getting my client's ID, who was a passenger. He pulled up, asked, and immediately started asking about the car when they were observed outside the car. He
Well,
had time.
does that make, do you think that the presence of them being outside the car should change the court's analysis here?
No, ma'am, I don't, because they weren't free to leave either way. And he premised the whole encounter
Well,
on a
in
vehicle
terms of
stop.
the safety, the officer's safety argument, I guess, is what I'm.
It's stronger. It's not like in Buzzard, where the 2 people were in the car, and the officer was asking through the window, and in checking had found out a lot of things about that Martin passenger in that case. So sure, I think it helps here. They were out.
It helps your client, you mean?
Yes, ma'am.
Yeah.
He could see their full bodies.
Could you recount all of the many ways in which this record seems to me to demonstrate that this officer did not feel that he was in any danger and in fact said he wasn't?
Oh, gosh. He did not even really react when told there was a gun under the driver's car. He did not immediately secure it. He allowed her to re-enter the car 2 times, further than arm's length away, where had she reached up under the seat to do something with it, he couldn't prohibit her. He was in his tack gear. I don't recall if he was armed. Government counsel may be able to answer that. But then looked at the gun briefly at like the 5-minute mark in the body cam, put it back down on the seat.
Well,
He didn't secure, go
She
ahead.
said something about, he asked her if she had a concealed weapon permit, and she said something about the new law.
And that's correct. That
And he
was
said-
6177C.
And he says, that's right, and then he puts the gun back down.
Yes, ma'am.
Okay.
He leaves both guns there. Like you said,
Right.
he doesn't secure them, doesn't clear them, and in fact testified that he did not feel he was in danger.
Exactly. He went 3 car lengths away back to his truck to take pictures of their driver's license on the hood of his car, at one point with his back turned to them.
And left the guns with
Left them in the
them.
car. And simply verbally said, y'all don't get in the car. And of course, they complied. They were outside the car when he pulled up. So the emphasis on the inside of the car when he's investigating what? Blocking the bridge. I saw no investigation of the traffic violation at all. I saw him going through the officer's laundry list. Well, here are the things I can do since I have a traffic
I thought they
violation.
were blocking the bridge.
They were. That's not in dispute. He didn't check to see if they were
Well, is that
intoxicated.
a traffic violation, blocking
It-
the highway?
Yes, sir, it is.
It is.
Yes, sir. No, that's not in dispute.
You mean that he stopped them for blocking the bridge, but then he didn't investigate anything about blocking the bridge? He went
Exactly.
he hauled straight off asking about
Exactly.
firearms 5 times.
Exactly. And what concerns me with the district court seemed to take the position, well, this is a constant, do you have any guns is going to be part of every traffic stop. And while Rodriguez does talk about, yeah, you can do some safety precautions to ensure you can have a safe traffic mission continued. Do you have a gun every
Well,
time
you
is
have
not
to-
part of it.
The officer has to do that, not just to protect himself, but to protect the people in the car and anybody else around.
You don't want an incident coming up as a result of somebody pulling a gun on you.
Well, that's the danger
That's
with,
what the thing's all about. And that's what Judge Berger basically said.
in every case. When here, they were outside the car, so what was in the car didn't even matter. They weren't visibly armed.
And
He did
Mr.
not
Martin
believe-
on the
Well,
video, he's like, I don't know, pacing or something further away from the car. He's not even in, on the video it appears, she's close to the car,
Exactly.
but he's out in front of the car pacing or, I mean, or doing something, but he's probably, I don't want to say not in close proximity to the car, but definitely not in as close proximity as she is, right?
Exactly.
To the guns in the car.
And she was being evasive in his answering his question.
He didn't know that until he asked her 5 times, Your Honor.
But that's maybe the reason he asked her 5 times. He felt it was.
But what was the reasonable
And then
suspicion to
and-
ask?
And she admitted she'd been lying to him.
And she admitted also at the very beginning, I have a gun under my seat.
Well, and
he
she
ignored
didn't
it.
admit that there was a big gun under the other seat,
That's true, that's supported in
that
the
she was
record.
lying to him.
She was also looking for her registration and insurance for 3 of those additional questions, but had turned those over to him. So, let's construe it that way. He didn't know that. Are we gonna do this in every traffic stop? We're gonna ask you the question once about a constitutional right unrelated to the reason of the stop, and just keep hammering it, what? He didn't even articulate a basis for not liking the answer. What he did admit later is that, yeah, I stopped him for being stuck on the bridge, but I'm looking at ginseng. He's a forest ranger, and I've seen this mentality in cases. They believe everybody out in the woods who's not doing something they understand is
This
illegally
was in the
ginseng.
national forest,
Yes, sir.
sparsely inhabited. Hardly anybody out there,
Yes, sir.
and miles and miles from
Yes, sir.
a community.
Yes, sir.
I mean, you and I know where that is,
Yes, sir.
Cranberry Glade.
Yes, sir. This case is certainly distinguishable by Palmer. There weren't 5 air fresheners hanging in the car. There wasn't an excuse to go in and mess with the registration on the windshield, and there wasn't the perception of marijuana. There wasn't a P.O. box on a driver's license, which I've never heard of that being a problem, but apparently that was justifiable in that case. They had found out,
He's one officer by himself.
With 2 people in a car, he naturally wants to be safe.
yes, sir. That's not an
And he acted
dispute.
consistent with that proposition.
He didn't feel unsafe. He admitted that. He wasn't concerned about anyone pulling a gun on him. He wasn't worried about it.
Based on the recitation of facts you just went over earlier, he acted inconsistent with that premise.
Exactly.
And
That's the
said,
reason he asked her 5 times if there was another gun, because he suspected she lied to him.
He asked her 5 times because he thought there was ginseng in the car and wanted to explore something
And
else.
the
Is
5th
that
time,
what
she
he-
admitted there was another gun in the car. And
She
he's a
did.
felon,
Well, that did turn out that way.
What?
as it turns out.
what did he testify was the reason he asked her 5 times?
He didn't. He just kept asking.
Nobody asked him at the hearing why he kept
We didn't
asking?
develop why so many
Okay.
times. It was more I felt important to develop. He didn't suspect them of any violations other than being stopped on the bridge.
Well,
either one of
you were
them.
just saying that he was asking her 5 times because of the ginseng, but that's not in the record?
No, ma'am. What's,
I thought he was
yes.
asking her 5 times because she was talking quietly or something.
No. He asked 5 times. He admitted later, he had talked about, yeah, I encountered them because of the stop on the bridge, but it's, I'm always looking for ginseng. And the structure of the questioning is consistent with that later representation on cross, because there was no justification to keep asking the question. There was nothing in her behavior that was prompting it. There was nothing in Mr. Martin's
So it's the
behavior.
fact that he testified that he was always looking for ginseng and they were in the woods, that's where you're getting the inference that that's why he asked her 5 times.
Yes, ma'am. And I
But
don't
why
know-
wouldn't he
and I
ask
don't
her
know
if
that
there
that's-
was ginseng instead of if there's firearms?
Ma'am?
Why wouldn't he ask her if there was ginseng in the car then, instead of if there was firearms in the car?
Because these officers have been told they can ask safety questions during a stop to prolong it and avoid the
Wait, where are you getting that?
consequences.
Who told, where in the record is it that somebody has told these officers to ask questions to prolong the stop?
I didn't develop that, I'm inferring that from
Okay,
the
so you're
circumstances.
just, okay.
Yes, ma'am.
I mean,
We've got the cross where he really displayed that he had no other suspicion of anything going on other than being stopped improperly on the bridge. Before the audio kicked on of the body cam, she admitted she had a firearm. They discussed it, and as you observed, there was no indication she had it unlawfully, or that she had a, he didn't ask her about
well,
either
the
of
main
them.
thing is he left it in the car,
Yes.
and he left it uncleared, and he allowed them to meander about the car with
Exactly.
now 2 firearms in the car.
And thankfully, and what I also believe supports my client's case, is that they didn't behave in a way that indicated they were a danger to him.
So
even when
much
he
so
left them
that he
way.
drove them down the road to the reunion they were heading to.
Exactly.
I mean,
Exactly.
he's really in fear of them, wasn't he?
So what, besides my client winning or having this ruling reversed, what I'm desperately hoping the court does not do is adopt a per se rule that, sure, it's fine to ask about a gun in every case, because the circumstances under the totality of the circumstances doesn't justify and warrant that in every case. Rodriguez recognizes, and there are instances where, with a traffic stop, yes, it's a mobile vehicle. People are concealed in part where you can't see their body, they're in a car or a vehicle, say it's a truck. But just as with a home, even when you can't frisk someone walking out without a reasonable suspicion, it's still, the Supreme Court law is, it's by the totality of the circumstances, case by case. And that doing the firearm inquiry is broadening the safety concern, which is legitimate. But broadening the safety concern so much, where do you stop? If it applies here for guns, if you rule today that it's an ordinary incident of a traffic stop, we can do it every time, then widen a frisk. We already have Supreme Court authority saying that an officer can
Or
remove.
drugs, do you have drugs in the car that might harm me if I, or drug needles in the car that might harm me?
Well, you already
I mean-
ruled in Buzzard that that was okay under the facts of that case. And I've had cases where officers start off going, there's no fentanyl in this, right? They find some drugs in the car and they want to process the evidence. And they're asking them because they don't want to have a contact, because they bought into that fentanyl can do the contact overdose. That's not scientifically supported, but they certainly believe it. I've seen them have panic attacks coming into contact with it. And but that goes into, in that particular context, with that traffic stop, does a mission to process, why did that traffic stop require that? If they've gotten to where they're asking about drugs, there's more going on. And no, that is a separate criminal investigation under Rodriguez. Again, if you smell the marijuana, that's different. We saw that in Palmer. I think it's Palmer, I'm sorry, maybe Buzzard. I don't mean to conflate the two, but you understand what I'm saying. I am just about out of time, so are there any other, I'll save it for the rest on the end. Thank you for your attention.
Thank you, Mr. Coleman. Appreciate you. Mr. Randolph? Good to have you with us, Mr. Randolph.
Thank you, Your Honor. May it please the court. As you know, as you are aware, traffic stops are especially fraught with danger, and that's where this case begins. It's not that the officer himself feared at a particular time that his safety was at risk. It's the circumstances surrounding this stop from the beginning. As Judge King pointed out, we're in the Monongahela National Forest. Out there, there's no homes.
So you're not advocating, you're focusing your argument on the totality of the circumstances in this case, and you're not advocating that law enforcement can just roll up to every car in every stop and first question ask if there are firearms in the car?
That was not my position in our brief, Your Honor.
Okay.
And Now, that may be the practical circumstances at the end of this, once I started thinking about it, but no, that's not what I advocated.
Yeah, so that's not, so you're focusing on the totality of the circumstances here and the fact that it was in the forest and he was alone and there was no cell service and he was outnumbered.
Outnumbered, limited radio communications, and here's the officer safety issue. right?
Okay, so what are we to
And most
do?
everybody in the national forest has a gun.
And unbeknownst to him, there were 2 people in this particular car that had a firearm. until he
Right,
asked.
but then when he determined that there were 2 guns in the car, he left the guns in the car. He didn't secure the guns in any way, he didn't secure the people, he meandered about, turned his back to him. He in fact testified at the hearing that he did not feel like he was in danger, and he certainly didn't act like he was in danger. I understand about your argument about the inherent danger to law enforcement of traffic stops, but the totality of the circumstances and the facts and the conduct and the behavior of the officer here belie that in this case,
Your Honor, I want you
to me.
Yeah, but the fear of danger can be mitigated and minimized through training and experience. And if you look at the record and the testimony about Officer Radford's training, he's an ex-Marine.
Does it matter that they were standing outside the car?
I don't think in this circumstance it matters at all that they were standing outside the car. Certainly.
And she didn't go back in the car until he told her to grab certain things out of the car.
Correct.
Right. Yeah, so they were both, when he pulled them over, they got out the car. He didn't really ask anything as to, she volunteered a lot of information, but he asked, first thing he kind of asked is, do you have a gun or a weapon? But he doesn't ask about why are y'all blocking the roadway? Mr. Martin is probably, 6-7 feet away from the car. He's up there pacing or doing something. I don't want to say pacing, but he's not in close proximity as she is to the car, right?
Yes,
You would
Your Honor.
agree. So, in terms of the argument regarding officer safety, would that make a difference that he's not in the car? Had they been in the car, would that have made a difference? He says that makes his case even stronger, the fact that they were outside the car.
Well, again, at this point, the officer doesn't know anything because in his initial encounter, he doesn't know if they have firearms on them or in the car or anything. So the initial encounter, before the officer even got out of the car and met with Ms. Jarvis, who was the driver, Mr. Martin had already exited and went over the bank and was coming back up. The district court found that initial encounter involved 3 things. It involved an explanation of the basis for the traffic stop. It involved a question about the presence of firearms, and then it explained or requested her driver's license. And that's when they moved towards the car, the officer and Ms. Jarvis. And you're right, Mr. Martin does stand off to the front of the car, and it's kind of steering clear of that particular conversation. Now, there weren't 5 questions here, and not to split hairs, there were 4 questions about. So the first one was, do you have any firearms in the vehicle? That was at the initial encounter. The next question came as they were walking to the car, and that was, is there anything else in the car, for which Ms. Jarvis didn't answer. The second question was, ma'am, was there anything else in the car?
Because he was looking for ginseng.
He was not looking for ginseng, although he did say that in his, in the body cam, while he's waiting on the driver's license and criminal history check to come back. He explained to him, hey, I'm out here doing some ginseng work. I have it in these particular hollows in the national forest. But he said, actually, the reason why I stopped
Now,
is
everybody
because-
out there say they're looking for ginseng.
That's correct. And he actually even testified at the suppression hearing that he didn't have ginseng in those hollows. He was just trying to make small talk and try to see if there was anything else going on at that time. Very important, Your Honor.
That sounds like prolonging the stop
Except
for no
for,
reason.
except for Judge Berger said that did not prolong the stop because while those.
I
that
know, and
question-
that's what we're reviewing, but go ahead.
But while that questioning was going on, Your Honor, he was waiting for the operator's license check and the criminal history check to come back from Nicholas County 911. So she found because of that, there was no prolonging of the stop. Similar to the questions following the initial question about the presence of the firearm. She said those questions took place during the necessary functions of the traffic stop. And because of that, it did not unlawfully prolong the stop. Because at the time, they were still working towards getting license, registration, and insurance. So those are two important findings that the court made that should bear weight on the decision.
And he got a response that there was a felony conviction.
He did. When the criminal history check came back, actually the first thing that came back from 911 was Mr. Martin had a felony conviction in his record.
And what that was, 10 or 12 minutes or something?
So I believe that was in the range on the video of about 12 minutes into the stop. There were approximately 2 minutes that the officer testified, around 2 minutes that were unaccounted for because the video body camera was warming up.
So
and
then
getting
what
ready.
did he do?
Upon finding the criminal history of Mr. Martin, at that point, he essentially took a little more control of the scene and placed Mr. Martin in cuffs and indicated he was going to arrest him for being a felon in possession of a firearm. But back to the
Then he
circumstances.
took him to a picnic.
Yeah.
I must say Officer Radford was a good old country law enforcement officer, and yes, he did return him to the
I just
pic-
thought that was a West Virginia thing.
Yeah. He was definitely a good old country law enforcement officer who would not have been in fear in the forest, even alone. And in fact, said he wasn't in fear. And you said he was a Marine, which is another reason
was a
he didn't
forest
feel like
ranger,
he
wasn't
was
he?
in danger.
Yeah, so he was a Marine. He had in his history, he was a.
Right, so he was completely comfortable in that environment, looking at the totality of the circumstances.
That's his job, yes, he would have been, I think there's every indication he would have been completely comfortable in that environment. So, but it doesn't change the fact, when you look at the decisions of this court and the Supreme Court, when it talks about traffic stops being especially fraught with danger.
Just about every court in the country said that they're very serious period of time.
Yes, Your Honor, and
About
so,
every circuit, it said they could do what they did here, what he did here.
But that goes back to my first so then you are advocating that in every stop, regardless, in every traffic stop, first question, are there any firearms in the car?
Your Honor, I couldn't think, as I'm sitting here, of a less burdensome precaution that a police officer.
Except that's just the beginning. What about, all right, no firearms, is there any fentanyl in the car? Because that's dangerous to law enforcement.
If,
I mean, there's no limiting principle to your reasoning.
well, there is a limit, and that limit is, are we?
Firearms, just firearms.
Actually, no, I'm not, I wouldn't articulate that. I think the limit is the question for officer safety, or is it for an unrelated criminal
Well, but
investigation?
you said every traffic stop is inherently dangerous, so that would mean that question, per your argument, is for officer safety, so then that would necessarily mean that they get to ask it every time for every traffic stop. And I'm just asking what the limiting principle is there. Is it just they can ask about firearms? And nothing else? Or do
Well-
we go, the next step's gonna be, I'll be up here asking about fentanyl at every traffic stop?
Well, there may come a time, I suppose, when fentanyl could be the next issue. that the
Okay,
court-
well,
but this
and that's a
this
problem.
Today is, I understand, but today is a firearm question, Your Honor, and certainly there's less things more dangerous to an officer than a firearm that he doesn't know, he or she
And it's
doesn't know
not
about.
just the safety of the officers, it's the safety of the folks in the car and the public generally.
Correct. Everybody involved in the traffic stop. and
Everybody
nearby.
involved, everybody around. You don't want to get some people shooting guns.
Where in the record, where can I find where this officer said he felt unsafe?
Where he felt unsafe? Mm-hmm. So.
In the circumstances of this traffic stop?
So in his testimony at the suppression hearing, he did testify that he did not feel, at the time Ms. Jarvis was getting into the car.
He said that safety was always at the forefront of his mind.
Yeah.
He did testify to that, but he also did say at the time Ms. Jarvis was getting into the car, he testified that he did not feel his safety was at risk.
Right. He did not feel he was in danger
Correct, Your Honor. At
when
that
she
time.
was in there getting in the car that he knew had a firearm.
At that time. And of course, he also
Well,
testified.
when did he decide that he might feel he was at risk? After the attorneys got involved?
No, I
I
don't.
mean, it's how he felt at the time, is how he felt at the time. He did not feel in danger.
I think importantly here, though, the case law doesn't seem to suggest that his subjective feelings is important when it comes back to the officer's safety.
Right, and then that goes back to my whole thing about how
broad?
it has to be that you're advocating for that an officer can ask straight away in every traffic stop, is there a firearm? And the reason is because traffic stops are inherently dangerous for officers. And, I mean, that can be your argument. I think there's case law that would support your argument. I just want to understand your argument.
I think that's a fair conclusion of where I'm getting to. Like I said, originally I didn't argue that that should be a per se rule, but when I started preparing for today's, I think that was a practical circumstance of what could happen here. And if it's a question for officer safety, then it's a negligibly burdensome precaution that an officer can take during a traffic stop.
How does that work? You know, I'm curious because I'm from South Carolina and we have open carry laws. So if she says that, because it seems, and she, and then I'm assuming that's in West Virginia, the same case, she says he initially picks up the gun and then he puts the gun back down after he says, you have a permit. And she says, I don't need one because of the new law, is basically what she says. So does he have the right at that point to go run the serial number or any, I mean, like, once officer safety, he just, at this point, you're just saying he just needs to know that there is a gun in the car.
I think that's the key. Knowledge is the key for the safety of the officers and everybody else in this particular circumstance. Even at that point, I think importantly, you know, Officer Radford still believed these people to be law-abiding citizens. He had no reason to believe that either one of them couldn't possess. He was telling them they could shoot in the national forest, even after learning of the second. So, yeah, that is, it's the knowledge of it. And he did start to have concern once the information came that there was a second firearm after he'd asked 2 other times and got some evasive responses.
And
But-
so then what did he do? Leave the firearms in the car?
He did not even get the second firearm. The first one, he testified that he believed he set it back down on the seat, and he did not recall taking it back to his
Right, so
vehicle.
that doesn't indicate he feels concerned. He left the firearms there,
But what he did,
unsecured, uncleared, with two people.
but what he did do a couple things, Your Honor. And I think Judge Berger made an important footnote in her order. The things that he did was he used verbal commands to ask them to stay away from the car, which they did. They complied. No reason to amp it up beyond that in his circumstances. So they complied with his verbal commands. And he also, when he went back to his vehicle, he said he kept himself in a position, one of cover in case either one of them would try to get to the car, and 2, so that he could visibly watch him as he was running.
Didn't he have his back turned at some point?
He had to
in
walk
time?
away from him, but he also testified that he was looking over his shoulder to, you know, to keep them in his sight. So he did do a couple things, and Judge Berger, you know, pointed out that just because he didn't take every step that anybody else looking at the case should have taken, it doesn't mean that he forfeits all the things that are otherwise available to him, and that's those certain precautions that have been authorized. And so, if no other questions, I would just sum up by saying the judge did not make clear error in saying that the question was for officer safety and that nothing throughout prolonged this stop. And we would ask that you would affirm her motion denying, or her order denying the motion to suppress.
Thank you, Mr. Randolph.
Thank you.
Mr. Coleman?
Yes, Your Honor. Briefly, a couple of things. Going through these questions, she did 2 answer them. If you look in the joint appendix, JA 112 through JA, you go all the way through 124. That's the transcript of the body cam video at 31 seconds. You don't have anything else in the vehicle. Jarvis says no at 33 seconds. So there's nothing else in the vehicle at 42 seconds. At 44, Jarvis says, And then at 48, ma'am, there's nothing else in the vehicle. Jarvis says no. So she was answering his questions and denying it. And you're right, Judge King, she changed her answer later in it. But up to that point, she was continuing to answer the questions, and nothing about what she said was suspicious or inconsistent with her prior answers. The idea about the license check, there was no license check in this case. That's why I said Rodriguez says you either have to not extend the stop or at least complete the stop in the amount of time necessary to investigate the mission of the stop. The mission was, why were you pulled over? Did he inquire about if there was something going on between the two occupants of the vehicle? No. Did he observe to see if there was any trauma, any behavior, any manifestation of a characteristic that they should have been stopped in the middle? Didn't even ask why they were there. Were they taking a picture? Were they smoking a roach? Were they avoiding a deer? Why were they stopped? Nothing.
Hadn't they discussed earlier why they were stopped, though? Weren't they
Well,
looking
no,
for
they had
mushrooms?
that was 45 minutes before.
Yeah,
and why
so
they
they
were-
were probably still looking for mushrooms.
Well, that may have been a
something.
supposition, but the point is he didn't even ask or investigate the traffic violation at all. He called in a 27, which
They
he
did
said,
it at
sir?
12:25, the dispatch radioed Radford that Mr. Martin had prior felony convictions.
Yes,
The dispatcher did not report back on Ms. Jarvis's driver's license.
that's true.
And Officer Radford then requested the dispatcher to send another officer in his direction.
Which he never.
That's from Judge Berger's opinion.
Correct.
You said they didn't do a driver's license check. That doesn't,
And Judge
that's not
Berger's,
consistent with that.
Judge
He did-
Berger-
He didn't report back at that point, I guess. But he did come back and say that the passenger had felony convictions. She's got an S on conviction.
and then at the joint appendix at 124 with Judge Berger's findings, she also expressly found that Radford did not feel his safety was at risk, even after that. And the lead up is at 5 minutes and 17 into the body cam footage when he's saying he's calling in a 27, which is the joint appendix at 85 and also at 87. Again, he acknowledged on cross. They never gave him anything about the driver's license being valid at all. Instead, he called in and said, could you verify neither of those are prohibited persons, please? That's the only response dispatch gave, because there wasn't another basis. I will give this explanation. It's not in the record. My investigator in this case is a former South Charleston police officer. He disputed that a 27 was a 27 the way this forestry officer characterized it with dispatch through Somerville. It's not in the record, but what was significant to me when I didn't have a witness there to contradict the testimony, it wasn't previously in a report, was that whatever he said at 27 meant, it didn't happen that way. He never verified that license as to its validity. He was willing to accept the registration and insurance looking at the physical card. He took a picture of the driver's licenses and took a picture of the tag on the car. So I submit to you, he wasn't really seriously investigating the traffic stop at all. So I don't want to belabor that, but I ask that you consider it.
You lapsed into being an expert witness here now.
Sir?
You changed from being a lawyer to being an expert witness for it.
Well, let me switch hats. Your Honors, the worst thing to come out of this case, on top of my client continuing to lose it, would be if a traffic stop becomes a general warrant to investigate anything that can be lumped into some massive cloud of safety, officer safety considerations, because there's no limit on that. I brought that up. We've got court law limiting when we can frisk somebody, how we get them out of the car, things we need reasonable suspicion for. You want a limiting principle. Okay, it's,
That red light came on you.
yes, sir, it did. It says 25. Oh, I'm
Oh,
going
it's
over.
going over.
That's the other
Anyway,
direction.
that's what I would ask that you entertain with this and avoid coming out of it. Thank you.
Thank you. We'll adjourn court for the week and come down and greet counsel.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.